Hello, good afternoon, everyone. My name is Giacomo Delledonne. I work at the Scuola Superiore Sant'Anna in Pisa, together with my colleagues and friends, Giuseppe Martinico and Filippo Fontanelli. I am one of the editors of the STALS project and paper archive, which was initiated thanks to an idea of Paolo Carrozza in 2008. Our webinar today will be devoted to the presentation and discussion of a recent monograph by Micol Ferrario, Transnational Judicial Communication, Doctrinal Frameworks, Institutional Dynamics, and Empirical Evidence from the Swiss Federal Tribunal and beyond. It's a very recent book, as it was published by Routledge in December 2025. It's a book based on the doctoral research of its author. Micol Ferrario got her PhD from the Université de Lausanne in Switzerland, where she worked with the supervision from Pascal Mahon, an old acquaintance of the STALS group, and Federica De Rossa, herself a judge of the Federal Tribunal of the Swiss Confederation since 2022. Micol Ferrario is currently a lecturer at Bocconi University in Milan. We also have discussants, including Odile Ammann, Associate Professor of Law at the University of Lausanne, and Graziella Romeo from Bocconi University, which may not show up, but we will have a rich discussion. I'm confident we will have a rich discussion. We are very happy to present this book, which possibly fills a gap in literature. In her introduction, Micol Ferrario refers to the emergence of a global trend that is constitutional judges, supreme judges that refer to precedents from other courts abroad, from foreign courts. This has been quite controversial, above all in the United States, but it's for sure a global phenomenon. And this is testified, for instance, by quite significant collections of essays edited by Tania Groppi and Marie-Claire Pontereau, and more recently by Groppi, Pontereau, and Irene Spigno, a book titled Judicial Bricolage, in which there is also a chapter by Micol on the use of foreign precedents by the Swiss Federal Tribunal. So it's a book which focuses on one jurisdiction that may not come so often to the spotlight of the comparative constitutional conversation. And its approach, the approach followed in this book, is a mixed one, as it combines theoretical and empirical approaches. And there are also quite interesting comparative conclusions on the relevance of the use of foreign law by the Federal Tribunal of Switzerland. So I think I have spoken too much. So Micol, you have the floor, and thank you for accepting our invitation.
Thank you so much to Professor Delledonne, and obviously to all the organizers of this seminar. I just shared the slides. If you have issues in seeing them, do not hesitate to interrupt me. So, as Professor Delledonne suggested, my book focuses on a highly debated practice, namely the use of foreign precedents by supreme national courts. And as he correctly said, my book is based on my PhD thesis. When I started to investigate this topic, I was a little bit puzzled by the fact that even though national judges are constantly depicted as the most national subjects within each legal systems, they are at the same time demanded to solve, to confront with transnational issues. And it is especially in these cases that national judges resort to foreign precedents. This practice, as already stressed, was highly debated both in the EU and in the US. On the one side, it is undoubtable that, especially in controversial cases, it may be useful for judges to resort to foreign precedents because they give different perspectives on difficult topics. But on the other side, there still are several opponents to this practice who stress the fact that the use of foreign precedents may raise two main problematics. The first one is political in nature, in a way, and concerns the separation of powers principle. So the opponents to transnational judicial communication stress the fact that the free use by judges of foreign precedents in purely domestic cases may finally lead to conflate judges with the legislator. In the end, the judges would be authorized to introduce in the legal system, in the national legal system, new principles developed abroad. And there is another important issue raised with respect to transnational judicial communication that is epistemological in nature. So the question is, why a given foreign precedent and not another? The so-called cherry picking, in the words of Judge Scalia. So it is quite a debated topic. My book starts, therefore, from this tension, from the pros and cons of employing foreign precedents in judicial practice. And to approach this topic, I decided not to go in abstract, simply stating why it is good or not to employ foreign precedents, but I decided to enter this debate by taking into consideration a specific case study, that of the Swiss Federal Tribunal. As already stressed, Switzerland is a highly unexplored country, and especially the practice of the Swiss Federal Tribunal has never yet been analyzed in deep by comparative scholars. And that is why I decided to concentrate on this specific case beyond the fact that I was working and doing my PhD in Switzerland, so it was easier for me. When I started writing, I departed as an Italian citizen from a statement. When I approached Switzerland, initially in Italy, everyone said that Switzerland is a very permeable country, is a country open to comparative reasoning, and these are for a set of reasons. One, because it is a small country, so a country that needs more than the bigger one to resort to foreign examples, or again, because of the fact that it is a multilingual and multicultural country, wherein legal actors are familiar with comparison. In my book, I decided to test this assumption in the judicial practice. So I asked myself, is the Swiss Federal Tribunal that open to comparative experiences as Switzerland is described by legal scholars? And to answer this question, I decided to take into consideration its case law. More specifically, my book considers what I labeled transnational judicial communication. To make it simple, I decided to consider in my book all the times in which the Swiss Federal Tribunal between 2000 and 2023 explicitly quoted a foreign precedent in its case law. I decided to put here an example to give you a real account of what transnational judicial communication is, in my opinion. Here you can see that this is a judgment concerning surrogated motherhood, wherein the Swiss Federal Tribunal, in paragraph 4, quoted the Bundesgerichtshof, the Supreme Court of Spain, even from Italy, Corte Suprema di Cassazione, and finally, Cour de Cassation of France. So many times it referred to a foreign precedents. How could I finally test whether this assumption holds true in judicial practice? So my book proceeds essentially in 3 steps. The first one is quantitative in nature, because in my opinion, it was important to understand, if ever, how many times the Swiss Federal Tribunal explicitly quoted the foreign precedents in its case law between 2000 and 2023. This is the time frame I took into consideration. And here I decided to share with you some data, because I think that they give a real account of the practice of the Swiss Federal Tribunal and what this graph tells us about its practice. You can see here, out of the total number of the judgment, more than 164,000 delivered between 2000 and 2023, in only 315 judgments, the Swiss Federal Tribunal quoted at least one foreign precedents. So probably this is the data that counter the most the initial assumption, Switzerland as a highly open and permeable country. Luckily, when I decided to focus my attention on the number of citations, because here is the number of judgments containing at least one citation. So I move my focus to the number of citations in total. The total picture slightly changes. You can see here another graph, which is also contained in my book. And you can see that in total, between 2000 and 2023, the Swiss Federal Tribunal employed 714 foreign precedents. Therefore, even if the number of judgments is quite small, the number of citations is, on the contrary, quite high. You can see it here. For instance, only in 2002, we had 8 judgments and 8 citations, meaning that in each judgment, there was only one citation. Rather, for instance, take into account 2005, 9 judgments containing 50 citations. And also 2015, we had 24 judgments containing 67 citations. So quite a lot with respect to the number of citations. Well, I had this picture when I ended up with the quantitative analysis, but in my opinion, it was necessary to move forward and to see which were the most influential countries on Switzerland. And as you can see from this slide, the use of foreign precedents by the Swiss Federal Tribunal is quite, we can see, geographically situated. Let's take into consideration just the fact that in more than 50% of the times, so in more than half of the total number of citations, the Swiss Federal Tribunal referred to Germany. So Germany has exercised a long-lasting influence on the Swiss case law development. And this is an interesting data, in my opinion. But it is also interesting to consider that the other countries taken into consideration were, for instance, Italy, Liechtenstein, France, and Austria, countries with which Switzerland shares at least one language or the legal culture. It was quite surprisingly for me to see that, for instance, the US, the Supreme Court of the US, has almost never been quoted by the Swiss Federal Tribunal. Alongside 23 years, we have only 5 citations. So a very small number. This was the quantitative analysis that I decided to develop in my book. But I thought once I collect these data that it was also necessary to analyze them and to see, in order to counter all the fears concerning transjudicial communication, the role they played in the development of the judicial reasoning. And you can see it here. This is another image that I also insert in my book. And here I decided to sort all the citations to foreign case law with respect to their function. And it is interesting to consider this data that most of the time, so in 33% of the time, the Swiss Federal Tribunal employed foreign precedents in a guiding way, namely in order to orient its reasoning, especially when hard issues were at stake. Often, not always, when the Swiss Federal Tribunal confronted itself with so-called hard cases, it gave account of the comparative practice, as it was the case I showed initially about surrogated motherhood. The Swiss Federal Tribunal had to solve for the first time an issue concerning the recognition of a surrogated motherhood, and to do so gave account of the experiences of other European countries. However, a real engagement of the Swiss Federal Tribunal is shown also with respect to the so-called probative citations, namely when the Swiss Federal Tribunal has an idea, wants to interpret an issue in a given way, and includes a very brief citation to a foreign precedent in order to show that also over there they decide like this, so in order to straighten its own position. I cannot go in details of all the data that you can see here, but you should take into account that sometimes you see 1% out of the total. The Swiss Federal Tribunal also employed foreign precedents in a contrario way, namely to take the distances from a given reasoning. And also we have here the two datas on the left. You can see that sometimes foreign precedents are employed in a way that I call borrowed. So when it is not the Swiss Federal Tribunal directly that introduces these foreign precedents, but rather, for instance, lower courts or the legal representatives of the parties. And there is another interesting data which I think further legitimate these qualitative analyses regarding the so-called false friend. Sometimes I picked a reference to a foreign precedent, and once I started to read the judgments, I immediately saw that it was a false friend, namely a citation that does not give an account of an engagement of the Swiss Federal Tribunal. Let's think, for instance, cases in which the Swiss Federal Tribunal says this case is also pending before the Corte di Cassazione Italiana. This is a false friend. essentially, because there is no use, no concrete, no real engagement with a foreign precedent. I decided to end up in my empirical analysis with another question concerning why the Swiss Federal Tribunal engages with foreign precedents. And to answer this question, it has been necessary for me to interview some of the judges of the Swiss Federal Tribunal. I want to highlight some because it has been difficult for me to access the Swiss Federal Tribunal because of the fact that some judges are still reticent in giving information about this practice. Overall, with respect to the why, so the reasons behind this practice, almost all judges agreed in saying that it may be useful to resort to foreign experiences, especially when controversial issues are at stake. So when they are demanded to confront with difficult cases. And it was interesting to interview them. I briefly move to the conclusion of my presentation. So what does this analysis tell us about the Swiss Federal Tribunal's practice and more in general about transnational judicial communication? So first of all, the Swiss Federal Tribunal seems, in a comparative perspective, to be more active than other civil law courts. If we take into consideration Italy or France, we cannot but immediately see the difference between the Swiss Federal Tribunal on the one side and these civil courts on the other. However, the picture is a little bit nuanced because, as I tried to explain before, there is an engagement with foreign case law, but this is not routine. Namely, the Swiss Federal Tribunal engages in a greater or lesser extent, depending on the topic, with foreign case law, but this is not routine. It does not happen every time. Despite so, we can say with respect to the so-called political risk, namely whether this practice is that dangerous as feared, that the Swiss Federal Tribunal gives a quite reassuring image because of the fact that most of the time, or maybe in the total, always, the Swiss Federal Tribunal has employed foreign precedents in a interpretative way, never in a normative one. To make it very simple, the Swiss Federal Tribunal has never set aside national law in favor of the foreign one. So this is an important aspect to consider. And also with respect to the epistemological risk, we have seen here that the countries that are quoted by the Swiss Federal Tribunal are always the same. Consider that in 91% of the cases, the Swiss Federal Tribunal only referred to Germany, France, Italy, Liechtenstein, and Austria. And this is with respect to this precise aspect that my critique lies. And it is precisely with respect to this aspect that my book makes a suggestion to legal scholars, which is the following. Probably when we take into account the judicial use of foreign precedent, we should move our attention from the question of legitimacy to the question of the method. The Swiss Federal Tribunal, as I said, gave us a reassuring image because foreign precedents have been employed in an interpretative way as an addendum to the reasoning, never as the sole legal basis. But the use of foreign precedents is still outcome-driven and very selective. Almost all the times, always Germany or France or Italy. My suggestion with respect to this point is that probably we, as legal scholars, should try to develop a method that could be proposed to judges in order to suggest them, once they decide to compare, to take into account more cases in order to concretely benefit from this practice, because of the fact that the Swiss Federal Tribunal, by doing so in a very selective way, has never probably profited as it could have done in general. So I think I am in time, and these were my conclusions. Thank you so much.
Thank you. Thank you. You are definitely on time. Slightly less than 25 minutes. So thank you. And so you have provided us with an interesting picture of your method and some of the results of your inquiry. Now it's time to listen to our first discussant, Professor Odile Ammann from Lausanne. You have the floor.
Good evening, buonasera, and many thanks for the invitation to participate in this book talk. I'll have the pleasure of chairing another discussion of this book at the ICON conference in Dublin this summer, but I'll only be the chair. I won't be a discussant. So it's very nice to have the opportunity to share some thoughts on the book today before taking the role of the chair in a few weeks' time. So first of all, I'd like to congratulate Micol on this great achievement. I was able to witness how parts of this research emerged and developed, and I'm very happy to see that the project has now been published with a great publisher. And this will enable it to reach a global audience and to not only contribute to broader discussions about transnational judicial communication, but also to help give more visibility to the Swiss judiciary and to the Swiss legal system, which can in turn then facilitate the reception of Swiss judgments abroad, hopefully. For tonight, I tried to identify a few clusters of issues that came to my mind as I was reading the book and that particularly struck me. And so I'll try to organize my remarks around these broad themes. So there are three themes that I'd like to emphasize in my comments. First, some conceptual questions around transnational judicial communication. I should perhaps say TJC to go a bit faster, but I'll try to pronounce the full expression throughout my comments. Then a few methodological reflections on your empirical research, which I found very interesting. And then third, some thoughts about the future of transnational judicial communication. So let me begin with the conceptual framework of the book. Obviously, one of the central concepts running through your analysis is transnational judicial communication, which is often described in terms of dialogue, conversation, or exchange between courts, even if, as you emphasize in your book, it can sometimes resemble something that is more like a monologue. As I was reading the book, I wondered whether transnational judicial communication is not, in most cases, actually a one-way street, or at least an asymmetrical process. This is, for example, the case between Switzerland and Turkey. As you know, Switzerland had an influence on Turkey in the field of private law in particular, and in some other areas, but private law is one example. Switzerland does not import Turkish case law or almost never, while Turkey does rely on Swiss case law. While Swiss courts rely on foreign judgments, at least in some cases, they more rarely serve as sources of inspiration for the jurisdictions it relies on. And then there are other courts which are very influential, like the Bundesverfassungsgericht or the US Supreme Court, which mainly seem to function as global exporters of legal ideas, while others import their judgments. So this made me wonder whether transnational judicial communication is perhaps more hierarchical, unequal, and even unilateral than the word communication actually suggests. Are we really dealing with communication, which involves a sender and a receiver of a message, or are we dealing with patterns of influence and with selection biases? So what exactly is at stake in these asymmetrical relationships? Relatedly, I wondered about the factors that shape the selection of foreign judgments. You explained that courts tend to rely on decisions that have persuasive authority, but of course, other factors are also at play, and some of these factors are explicitly mentioned in your interviews. Linguistic factors, that's a big one, accessibility, institutional prestige, ideological affinity perhaps, or simple familiarity of one judge with a particular legal system. And your empirical findings are very striking in this regard, and you showed this again in your slides. German case law is actually a jurisdiction or an example that overwhelmingly dominates the citations of the Swiss Federal Tribunal. So of course, to some extent, this is unsurprising given Switzerland's linguistic composition and cultural context. German law has had an enormous influence on Swiss law. But this dominance also raises broader questions about the politics of comparative reasoning and selection bias. Are certain jurisdictions considered more citable than others? Is this just linguistic bias because German is the most prevalent language in Switzerland and at the court? Are these selection biases unavoidable, or should they be challenged and addressed? This also made me wonder whether the concept of transnational judicial communication may sometimes be somewhat over-inclusive, because it encompasses very different types of practices and institutions, as you explain in your book, horizontal, but also vertical interactions, domestic, international, supranational courts, constitutional adjudication, references to the case law of the European Court of Human Rights, and so on and so forth. And now the question is, are all of these practices and institutions really comparable? In some context, the reliance on foreign or international judgments is not entirely voluntary. It may derive from legal obligations connected to international law, to the European Convention on Human Rights, to EU law, at least in the EU member states. Switzerland is not a part of the EU, or private international law. On the one hand, in your analysis, you acknowledge that there are instances of mandatory use of foreign case law, for instance, in the context of the preliminary ruling procedure. Again, this does not concern Switzerland since we are not part of the EU. And on the other hand, you consider that transnational judicial communication only covers voluntary use of foreign case law. And therefore, I would be interested to hear more about how you understand the boundaries and the normative foundations of this concept. How does it relate to what you refer to as hard versus soft use of foreign case law, which is use with or without the attribution of precedential value to the case? And does transnational judicial communication also apply to domestic cases involving an international legal dimension, or is it limited to purely domestic situations, as you write in your book? Does the normative basis for transnational judicial communication differ between civil law and common law jurisdictions, and so on? So there are many questions that popped up in my mind in relation to this concept. And finally, I was particularly interested in your discussion of the Swiss context. Switzerland appears both very open and very cautious with regard to this practice. Open because of its small size, its multilingualism and multiculturalism, but also very cautious because of its semi-direct democracy, its limited constitutional review. The Swiss Federal Tribunal cannot strike down federal laws, and concerns about the separation of powers and judicial overreach. What do you think are the implications of these characteristics for the practice of transnational judicial communication in Switzerland, especially considering the political affiliation of Swiss judges? As you may know, federal judges are all part of a political party. Does transnational judicial communication necessarily reinforce judicial activism? I'm not a big fan of this term, but critics use it. Does it reinforce judicial activism as critics sometimes claim, or could it also operate as a form of judicial restraint? Because you could also use foreign cases to actually embed more conservative decisions within broader comparative trends. I now turn to the second cluster of remarks and questions which pertain to the empirical dimension of your study, which I found extremely rich and original. Your work makes a really important contribution to empirical legal scholarship on the Swiss judiciary, especially through this combined quantitative and qualitative analysis. One aspect that especially interested me concerns the methodological challenges associated with elite interviews, as you explained. In a sense, these interviews are themselves a form of judicial communication with the outside world, and perhaps even a form of judicial PR. And this raises obvious questions about self-presentation, about managing the court's institutional image. So to what extent can we take such interviews at face value? How did you deal with the risk that judges might be reluctant to openly share the details and the motivations of their practices? Were there moments where you felt that it was necessary to kind of read between the lines? I found it quite striking, on the other hand, that some judges very candidly acknowledged that their use of foreign case law is outcome-oriented, at least for some of them. So in some cases, they were very open about their practice. I was also very interested in your discussion of access to interviewees. You explained that access was facilitated by institutional gatekeepers and close professional connections. Some of them are in this virtual room. And this made me reflect more broadly on the structural difficulties of empirical legal research. What would have happened without these institutional connections? What are the implications of such barriers for empirical legal scholarship in general, and how could these barriers be overcome? Another question that repeatedly came to my mind concerns the role of law clerks and of the Swiss Institute of Comparative Law. You explained throughout the book that these are very important actors that support and hence facilitate transnational judicial communication. And this raises an interesting structural issue. Is transnational judicial communication partly or even mostly a question of resources? Are legal systems with greater institutional support and with more research capacity more likely to engage in comparative reasoning and in high quality comparative reasoning? If so, could current technological developments such as generative AI eventually reduce these disparities? And finally, I think that it would be worthwhile in a future project, maybe in your next book, to also interview law clerks, because it's usually them who draft the judgments and who have more time to do extensive research. So it would be very interesting to get their insights as well. I also wondered whether the interviews reveal deeper ideological divisions within the Swiss judiciary itself, or methodological divisions. Some judges appear receptive to comparative reasoning, whereas some remain more skeptical. Does this suggest that transnational judicial communication is ideologically charged, or is it mainly something that depends on the subject matter of the case? For example, you found that it's more common to rely on foreign judgments in the civil law division and in the public law division than in criminal or social law divisions. Your study is primarily descriptive, but the conclusion does occasionally include normative recommendations. And in your conclusion, you suggest that comparative judicial reasoning could benefit from more methodological clarity and consistency. And I found this especially interesting because the great heterogeneity of practices that your interviews revealed, the reasons and the way of resorting to foreign judgments varies enormously among the judges. This heterogeneity seems to point towards genuine epistemological risks. For example, selective borrowing, inconsistent methodologies, uneven engagement with comparative examples. So in light of this eclecticism of these very diverse approaches to foreign precedent or foreign judgments, what would a more methodologically rigorous practice of transnational judicial communication look like? Is it even possible to draft guidelines on the topic? And in your view, what are the main strengths and the main weaknesses of the Swiss Federal Tribunal's current approach? And now finally, the last series of comments concerns the future of transnational judicial communication. Your book repeatedly emphasizes the linguistic embeddedness of law, the importance of language in shaping comparative judicial practices. But currently we are witnessing a very rapid transformation of legal research technologies, particularly through generative AI, and it's literally everywhere. And until now, DeepL and similar translation tools had already dramatically facilitated access to foreign judgments. Now, generative AI may go even further by allowing courts to navigate foreign case law far more easily and to overcome linguistic boundaries. How do you think these technologies will transform transnational judicial communication? Could generative AI broaden the pool of judgments taken into account by courts such as the Swiss Federal Tribunal? Might it reduce some of the linguistic and resource-based asymmetries that currently shape this practice? That's the positive outlook. Or if we want to take a darker kind of view, is there a risk that AI could actually encourage superficial and performative forms of comparison without necessarily deepening the court's engagement with foreign case law? And this ultimately brings us back to the fundamental normative question that underpins your study, or that could be asked at the end of your study: what counts as good transnational judicial communication? And finally, I was also very interested in your brief remarks about the migration not only of liberal constitutional ideas, but also of anti-constitutional illiberal ideas. Now, in light of current geopolitical developments, how do you see the future of transnational judicial communication? What about traditionally highly influential jurisdictions, such as the United States? Your empirical findings suggest that direct references to US case law were relatively marginal in the Swiss case law anyway, despite the enormous historical influence of US constitutional law more broadly. But still, your study refers to several judgments of the US Supreme Court, and the court has itself massively influenced a lot of debates about transnational judicial communication. So how do you expect US influence, for example, to evolve in the years ahead? Okay, so now I've raised 4 more questions than you could possibly answer this evening. Don't be afraid, I don't expect you to answer to every single point. It's more to provide food for thought for the discussion. And the many questions reflect the richness of your book, the number of questions I wrote down while reading the book is directly proportional to the interest that I had in your book. So once again, congratulations on this very impressive achievement, this great contribution to legal scholarship and empirical legal research, and I look forward to the rest of our exchange. Thank you very much.
Many thanks to Odile Ammann for her intervention. Indeed, there is pretty much food for thought, and I'm sure we will have an amazing debate. Now it's the turn of Graziella Romeo to join us. Graziella, you have the floor.
Thank you. So first of all, apologies because I entered the meeting slightly late. I am in this situation because I have a quite serious problem with my right ear. So I'm sorry for presenting in this way, but I really wanted to be here tonight for Micol, for the interest that I have in her work, and for the many friends who are connected for this book discussion. I have organized my comments around 3 ideas as well. I will probably be brief because of the pain, which is at least a good news for the audience, and will probably leave some space for discussion. So my 3 ideas revolve around 3 concepts: the ideology of transnational judicial communication, the geography of transnational judicial communication, and what I call, in a not so precise way, the genealogy of transnational judicial communication. And let me start with the first one, the ideology of transnational judicial communication. I use this term because I was quite interested in the fact that if you read Micol's book, her discussion of arguments in favor and in opposition to transnational judicial communications, the way she phrased those arguments is arguments from partisans and from opponents. And the use of this terminology made me think whether Micol believes that there is somehow an ideological vision behind those different approaches. She, in her book, she says that she calls the arguments that resist the use of foreign precedents political arguments, because they are based on a certain thick understanding of constitutions as political expression of people's will. Now, these I have to say that this debate, the ideological charge of this debate, never fully convinced me, and I will try to explain why. So, philosophical accounts of transnational judicial communication tell us that there is no problem with the citation of foreign precedents as long as those citations are part of the argumentation, what Micol was saying. It's the picture, she said, the picture of the Swiss tribunal is quite reassuring. And it's reassuring because all those citations are always made to support and never never as sources of the decision. So you don't strike a law, you don't consider a law unconstitutional because a foreign source tells you to do that. True. I wonder to what extent, from a legal, realistic perspective, this is actually something that we can use to defend or not defend, whatever is our position, the use of foreign precedents, because there are two, I think, important truths from a legal, realistic viewpoint. The first one is that those arguments are strategically used in argumentation, so they can be very persuasive, and persuasion has a very strong power in constitutional argumentation. And second, constitutional argumentation is a big deal because in many cases what actually circulates is the argumentation, is not the decision. So I'm not so convinced that if we say, well, those are not authoritative sources, we can rule out the discussion. I don't know what is Micol's view about the use of foreign precedents. My understanding from her work and from her presentation today is that she tends to believe that a careful use is better than a use that is instead charged with authoritativeness. My conclusion is that in any case, whatever is our position, we can't really have a position if we don't do the kind of analysis that Micol did, meaning a granular analysis of how courts use foreign precedents, to what extent, the number, the circumstances, the years, the recurrence, all these pieces of information are crucial to have a position. So my view of this debate is that you can't really have a position without a deep contextualization of the use of foreign precedents. And that's why I think that these kind of studies are particularly important in comparative constitutional law, because what it's called the political, what Micol calls the political argument, is not completely devoid of meaning from a strictly legal viewpoint, and there is some value in the positivistic approach of those who take that stance. It's not exactly my view, but I can see the conceptual value in that position. But it doesn't solve the problem, because even if we say, okay, let's rule out the possibility to use foreign precedent and sources of law, this doesn't make foreign precedent less relevant at all. And I think that the American debate in that respect is actually very interesting. As you might know, in the US, the use of foreign precedents is absolutely even not conceivable. It was an epiphany in the history of the Supreme Court. But the power of the debate is significant in the case law of the Supreme Court concerning the death penalty. So they don't cite precedents, but the conceptual bearing of the debate is incredibly relevant for the positioning that the Supreme Court's justices are expressing towards death penalty. And, there are a few people in the US who believe that the jurisprudence on death penalty will at some point change, whatever is the ideological position of the Supreme Court justices in the bench. So even if the current conservative majority keeps running the court. And this is, I think, a proof of the fact that the power of arguments can't be dismissed. Second point, the geography of transnational judicial communication. And here I very much agree with many of the things that Odile said before me. I think it's very interesting to map what are the courts that are mostly cited, and as both Micol and Odile were saying, this is due to many factors, including, I think Odile mentioned this, the availability of judgments and the accessibility of judgments. And so the linguistic competence of the judges is not, of course, irrelevant. Another thing that I found very interesting, and that actually Micol discusses in the chapter on interviews, is the background of judges, because at page 2014, Micol says generally the judges that engage with foreign presidents are judges that have the occasion to know them, to study them, and that's because they have they hold PhDs or because they are professors. So the academic background plays an important role, which I think reinforced the fact that argumentation is an important element of circulation of ideas. But the geography can work also in another sense. This is something that Odile mentioned at some point, and also Micol discussed in the book. There are courts that are probably better positioned to make use of precedents. I'm not an expert on judicial precedent, but I have studied quite a lot argumentative approaches and argumentative styles of courts. And this idea of a hierarchy that Odile mentioned, the risk of transnational judicial communication that is implicitly somehow hierarchically organized, here is particularly evident because you can have courts that either because of their positioning in a small country, in a country that is deeply multicultural, are either more expected to use foreign precedents, or, if you wish to reason contrario, more justified for using foreign precedents. While the same approach by courts in other jurisdictions might sound as if those courts do not trust enough themselves or their body of precedents. So I think that this geography of transnational judicial communication that Micol was mentioning in his book, I think can work both ways. And I'm telling this, Micol, because probably there is room for an article on this, because you can use comparative law to try to understand the extent to which the positioning of a court, the prestige, Odile was mentioning the prestige of certain courts. For sure, the German Constitutional Court works also in the other way around to justify the reason why for those courts to use precedents is a big deal, which is, by the way, the real reason, in my opinion, why the Supreme Court doesn't want to use precedents, because the Supreme Court doesn't want to lose the idea of being a court that is highly influential to other courts. And for how the Supreme Court tend to position itself, and also partially because of American legal culture, the use of foreign precedents is somehow interpreted as a way of being subject to a cultural influence as opposed to shape cultural influence. And this goes back to what Odile was saying about the true nature of this communication. Is this communication bilateral, multilateral? And so are we creating an environment in which all courts are willing to cite one another, to discuss with one another? Or are we creating sort of influential courts that either you have to cite to legitimize your reasoning, or you have to side or engage with to show that you know and you are part of a debate, which is quite a different approach. And again, this underlines again the importance of empirical research in this topic. As you may have noticed, I think that this is really a topic in which empirical research is more important than theoretical reflection. And you can have theoretical reflection, but it can't be independent from empirical research. Third point, what I've called the genealogy of transnational judicial communication. So when I started reading Micol's book, I must confess, the first thing that I have done was opening the table of contents, which is what I always do. I rarely start from the beginning. I always try to start from a paragraph, a chapter that really takes my attention, and then I develop the. Sorry, can you hear me? Yes, and then I develop my idea on that book. And in the case of Micol's book, I was very much interested in the factors influencing the use of foreign case law by Swiss Federal Tribunal, the institutional factors. At the beginning of this chapter, which is chapter 6, Micol mentions the techniques of legal interpretation, and she discusses in particular Article 1 of the Swiss Civil Code. And I found this very, very interesting. I found very interesting to connect. That's why I called it this part of my comments, the genealogy, to connect the use of foreign precedents with the interpretive approaches, interpretive doctrines. And what I find really interesting in Micol's account, I think I'm speaking too much, let me check 1 second, is that yes, I will be very brief, 2 minutes. Is that Micol mentions the fact that anti-textualist approaches are actually more welcoming for this type of engagement with foreign precedent. And again, I don't have much time, so I will quickly close on that. I think that this is again there is a large avenue for more research on that, both in comparative perspective and with specific attention again to the Swiss Constitutional Tribunal. This is a very important insight that you are giving us. Thank you, and congratulations again for your book.
Thank you. Thanks indeed, Graziella, also for your endurance. So very precious comments. Now we have a couple of minutes for raising further points, for asking questions, after which Micol will have some time for her reply. So I invite those who wish to ask questions to raise their hands if interested. Giuseppe Martinico.
Yeah, thanks indeed. But just to break the ice, I really enjoyed the book as we said it, and that's why, of course, I mean, we invited Micol to present it. That I also enjoyed the discussion. I have two questions. The third one is on the selection of your cases, on the selection bias, I would say, of art cases better, because you noted that foreign law is predominantly cited in art cases involving sensitive societal issues like surrogated motherhood. In these morally and politically charged fields, does the use of foreign law serve as a tool for genuine inspiration, or does it function as a strategic shield for judges to legitimize the controversial cases by saying, look, other nations start doing this too? What do you think about that? Second question on the hegemony, let's say, of some experiences. You mentioned that the Swiss Federal Tribunal's engagement remains, I'm quoting, methodologically narrow due to its heavy reliance on a German case law. In an increasingly globalized world, do you see a risk that this German-centric bias creates a form of legal path dependency, preventing this way the Swiss Federal Tribunal from exploring innovative legal solutions coming from non-German jurisdictions or cases? Thank you very much.
Thank you, Giuseppe. Umberto Lattanzi.
Hi, good afternoon to everyone. Hi, Micol. Thank you for your presentation. My question is on your last remark, and it's actually a request for like additional clarification or additional something. And so on the methodological aspect, you say, okay, there might be room for improvement for the courts in doing these references to foreign materials for clearer methodology. And so my question would be, do you think that the courts doing comparative law or like having a reference to foreign precedents need a methodology that is different to what comparative law usually does? Because I would say methodology is something you need for a purpose. And so if we use a method to produce new knowledge is one thing. If you use a method to, I don't know, what is the function of comparative law for the courts, and you put down a taxonomy of this. And so this is it, basically. So how would you consider the connection between the methodology you think courts should employ with the function of comparative law and reference to foreign materials for the courts? Thank you very much.
Thank you, Umberto. Well, I also have a question regarding the appointment process of the judges. So you have focused on the, let's say, objections that have been raised in the past few years against this procedure. And so the first point is there any relevance? I don't think so, but I'm asking. Any relevance of the use of foreign precedents in the selection of judges of the Federal Tribunal? And second, is it possible to identify patterns among the judges of the Federal Tribunal when it comes to referring to foreign materials? Thank you. Now, I don't think any other. So, Micol, please.
Thank you so much to everyone, to Odile, to Graziella, and also to you for these relevant questions. I will probably start from the end and then go back to the beginning. So I will start answering the question of Professor Delledonne. When I decided to interview the judges of the Swiss Federal Tribunal, I was almost totally sure that I could find a sort of connection between the political party they belong to and the quantity, or better, the approach towards the use of foreign precedents. And my assumption did not hold true, in the sense that there is no pattern. Instead, despite belonging in a totally transparent way to a given political party, judges interact with foreign precedents in a totally personal way. So for what I saw, for what I heard from judges, I can't say that there is a connection between belonging to a given political party and behaving in a certain way with respect to foreign precedents. But this is an interesting point that I tried to analyze also in my research. So thank you so much. So with respect to the question of Umberto, thanks to you too, you asked me the methodology we should develop for this judicial practice is somehow different from the methodology we normally employ in comparative law. Probably my answer is yes. Indeed, I think that we cannot think of a universal methodology that can be applied to all courts, mainly because of the fact that there are several differences among Supreme Courts. But for what it concerns specifically the Swiss Federal Tribunal, the methodology should be should address at least the fact that not Germany should be considered, because during my presentation I didn't give account of this point, but take into consideration that out of 315 judgments, in 181, only Germany was quoted. So there is this long-lasting influence. So my very point about methodology is that probably we have to all contribute to develop guidelines in order to give the strength to judges to consider more cases when they decided to do so. Because if not, the use of foreign precedents is totally selective, and in order to take into account the comparative perspective as well, is not that beneficial, because it's simply something that we pick in order to reinforce a given interpretation. And this point gives me the opportunity to move towards the first question of Professor Martinico concerning the fact that foreign precedents are employed especially in hard cases. Yes, I do agree with you. I think that in these cases is a sort of a shield. The Swiss Federal Tribunal states the fully fledged image. It tries to describe how other courts approach the same problems in order probably to legitimate its position in a way. But still, we have to consider that the Swiss Federal Tribunal is brave, because in the end, even though the majority of foreign courts decide in a different way, the Swiss Federal Tribunal gives its personal account. But still, I had the impression that in some cases, for instance, surrogacy, the removal of gender marker, and so on and so forth, the Swiss Federal Tribunal states the full picture in order to describe how other courts behave, and eventually to state that it agrees or not with them. So I think that especially in these cases, it works as a partial shield, because our hard cases, new cases, and it is interesting to give account of how others behave. And with respect to the hegemony, yes, I think that there is a possibility to develop a path dependency, in the sense that there is a possibility that the squeeze case law, whether it is possible, I mean, will become very similar to the German one, or at least will take only into account the German example. And this is precisely because of that I think it is important to support judges with a new methodology, telling them, well, you should consider at least, I don't know, 5 countries to give a real methodologically sound and not German-dependent decision. So I think that's a real concrete danger, and that is why we should all try to move our attention from legitimacy to method. So to develop a method that makes judges feel comfortable at the end when it comes to the use of foreign precedents. Then finally, I will move to the comments of Graziella, who I thank so much because of the fact that she doesn't feel good, and despite of that, she decided to take part to this seminar. So thank you so much, Graziella. So with respect with the ideology, that's where I departed from in my book, because when I was discussing with Professor De Rosa the topic I wanted to develop in my PhD thesis, and I was coming from Italy, and I was telling her, but well, Switzerland is described as permeable country. And she always told me, you have to give empirical evidence of it, because you can't say that a country is permeable without grasping the real practice, so without data. And I do agree with you. I think that the theoretical debate does not really give account of the pros and cons of this practice, because it is necessary to take into account the single case study and even each single judgment, because in every judgment and all over the years, the practice has deeply changed. With respect to geography, thank you so much for this suggestion concerning the way around I can interpret the positioning of certain courts. I do agree with you that US Supreme Court does not want to give the idea that it needs foreign precedents to settle a case. As Posner stressed, no thank you, we already have our own laws. Thank you so much, because I didn't take into account in deep this aspect in my book, and I think it is something I can work on. So the approach of certain courts with respect to the ideas of others when it comes to the use of foreign precedents. Indeed, as you correctly said, the US Supreme Court does not employ foreign precedents oftenly, and the same holds true for Germany. If you look at some comparative studies concerning the German practice, is the same, is a almost total waterproof country when it comes to foreign precedents. So thank you so much. And thank you for having stressed the importance of Article 1 of the Swiss Civil Code. Sometimes, not Professor De Rosa, obviously, they told me, but it's something that is like overcome by courts. Courts do not really do their job by employing the traditional legal interpretations method. But I did not agree, and thank you so much for having stressed this aspect, which for me has been really pivotal in my research. Article 1, if you have never read it, I suggest you to do so because it's something very peculiar in the civil law panorama. And thanks also to Odile for all the food for thoughts that you gave me, and also for having been by my side from the very beginning. The first presentation I made of my PhD thesis was on the occasion of a seminar organized by Odile, like 8 years ago, I think, something like that. So thank you so much, Odile, because you saw the birth of my idea, and now you see the final project. So thank you so much. Probably I have to pick some of the suggestions you raised. All of them are profoundly interesting, and I will try to focus on the next days on them in order to further develop my research. But there are 2 points that I would like to stress. The first one, the 3 points actually. The first one concerning the hierarchy. Both you and Graziella stress the fact that are always the same courts that are cited by the Swiss Federal Tribunal, and more in general are always the same foreign courts that are included in this global debate. And I do agree with you. Probably in the future, I will stress more this aspect when talking about transnational judicial communication, because nowadays it is welcomed as a globalized practice, but actually it is not really like that. Second point, the empirical research, the access to the court. It was hard, really hard. To develop these elite interviews, but I had this chance, first of all, because I had a connection inside the tribunal, but I think also that the judges trusted me because I granted them the anonymate. So this is an aspect that probably should be emphasized for future researches in this field. When someone wants to develop elite interviews, in order to overcome reluctancy, it is necessary to utilize the anonymate, which is something that may undermine from like on other grounds the research. For instance, what Professor Delledonne said, so the connection between the political party and the judge. I couldn't state it openly, but still it was a way to reach the apex court of Switzerland. But still is a problem. I don't know how in the future this barrier and whether these barriers will be totally overcome. But at least I think that this aspect may be taken into account, may be stressed more in order to have a conversation with judges wherever they are. And what about the future? Thank you, Odile, for having stressed the impact generative AI could have on the development of transnational judicial communication. I totally agree with you that one of the main risks concerns the fact that if you employ as a law clerk, for instance, a ChatGPT in order to see how Italy, how France, how the US approaches a given issues, the risk is that in your judgment, you will cite a foreign precedent in a very not cautious way, not consciously, I mean, unconsciously. So this point leads me also to consider that probably in the methodology that should be developed with respect to this practice, a huge place should be consecrated also to the risks connected to generative artificial intelligence, because if most of the opponents state that transnational judicial communication may be dangerous because foreign precedents may not be deeply really understood by judges, I think that this aspect would further stress this critique, this positioning. So it's something that I will for sure include in my future researches. I think, yes, I almost answered all the questions, but I don't want to run out of time.
So thank you for being so precise. So I don't know if there are any further comments. Otherwise, I would like to thank again wholeheartedly Micol, Odile, Graziella, and all the participants in this webinar. I think we had a lively discussion, an interesting comparative debate, and well, this is a very topical trend. So I think we will have an occasion to speak about these problems again in the future. So again, many thanks, and see you at the next STARS webinar. Goodbye.
Goodbye. Thank you so much.